Thank you so much. So I want to thank the Economic Forum for continuing to extend an invitation for me to come and address some of the public safety challenges. Every time I'm asked to return to speak to a group, I think, well, we must have done something right, or at least given you something intriguing to contemplate. I know that a lot has been presented to the community from a variety of different perspectives on what needs to happen to address the crime crisis in this city and in this state. My hope today is to give you one perspective on what I think is one of the most critical aspects of the policy landscape that's impacting public safety in this community. Usually when I come to Economic Forum, I spend a fair amount of time talking about the status of our data partnerships with Sandia National Labs or New Mexico Tech. And those partnerships are ongoing, and we are in the process of building really some best-in-class data applications that I think will transform the way we work with law enforcement and transform the way we think about law enforcement. But today I think I'd like to focus on the most pressing political and policy issue, and that relates to pretrial detention. As many of you know, for the last several years, I have advocated for fundamental change in the structure of pretrial detention, and I think it's helpful to go back to the very beginning to figure out what went wrong in the implementation of this really important and transformative policy, and what we can do specifically to have a much needed course correction. I would say at the outset, and it's incredibly important because a lot of times the dialogue, especially when you're in the business of getting asked to give 15 and 30-second sound bites, is that we should either scrap the bail reform initiative or double down on what we've been doing. And I think what we really need to do is consider ways to improve it. And to do that, we have to go back to the origins. So I thought it would be helpful to actually show you once again the ballot question that appeared on the ballot in 2016 when 87% of the citizens of this state voted in favor of it. And this is the question that was presented. It was proposing an amendment to the Article 2, Section 13 of the Constitution to protect community safety by granting courts new authority to deny release on bail pending trial for dangerous defendants in felony cases, while retaining the right to pretrial release for non-dangerous defendants who do not pose a flight risk. I will tell you at the outset that the system as designed has fundamentally achieved the second half of that question that was presented on the ballot. What it has failed to achieve, in my estimation, is the most important and highlighted portion of the question. And frankly, I would argue that 87% of the public voted in favor of this amendment because they thought they were voting for the first part. And while they cared about the second part, and the second part is an important and laudable goal, it's the first part that we need to fix and we need to get right. The problem is we came out of the gates with a flawed constitutional structure. The original language that was presented to the committee in the legislature that was going to consider the question was presented with an entire framework that is in alignment with the three primary ways that you can detain an individual in this country, and it's been in place for decades. The federal government has been doing this since the mid-'80s and the passage of the Bail Reform Act. Washington, D.C. has been doing this for decades. A number of states around the country have a system in place, and there are three bases for moving for detention, and they're pretty straightforward. One is dangerousness. Is this person too dangerous to be back in the streets, in the community? The second is flight risk. Is this somebody who, while not dangerous, poses such a substantial risk that they won't show up to court that we need to keep them detained so that we can move their case forward? And the third is obstruction of justice and intimidation of a witness. What you can see in comparison to, for example, New Jersey's framework is the fundamental flaw in the passage of the constitutional amendment, which omitted the second two prongs of what is everywhere else in the country standard constitutional language. Unfortunately, this has had broad implications for our office, and one of the things that comes up on a regular basis is why our office does not move more frequently to detain property offenders who have a long criminal history but no violence. And what you can see from just looking at this constitutional structure, we don't have the authority under the Constitution to do that in the absence of a gun or a current crime of violence. But it's compounded by something that has occurred under the water surface. And that has to do with the implementation in this county, and it's only in effect in this county, with something that's called the Arnold Risk Assessment. You may have heard about this. There's been a lot of public debate, especially by studies that have been presented by the court about its relative effectiveness. This is the tool that guides judicial decisions about whether or not someone should remain in custody. What has been missing largely from public view is the implementation process that goes along in every jurisdiction that passed bail reform. And so, for example, if you look at New Jersey, what they've done is, in addition to the basic matrix that the judges use and rely on, they ask an additional 10 questions. Controversial things like, did this person commit a murder? Did this person have a firearm? Has this person been engaged in violent criminal activity in the past? Arizona has additional steps. Santa Cruz, California has additional steps. The reason I raise this, these are all Arnold jurisdictions across the country. Look at the state of New Mexico. We adopted in a committee that was formed under the guidance of the judiciary, outside of the legislature, and frankly outside of public view, every recommendation for supplemental guidance for the Arnold tool was rejected in those committees, which unfortunately leads you to some very bizarre outcomes, because the tool that was developed and is implemented in this jurisdiction was built for those other places where they have a full constitutional framework. And what does it do? It leads you to situations like this. This is Daniel Espinosa, and I'm giving you just a snapshot. This could be an example of something that you might see in any given day in Albuquerque. Daniel Espinosa was charged on January 6th of 2020 with possession of a controlled substance, paraphernalia. He had no violent felonies and property and misdemeanor cases. But if you look at his score and look very carefully up at the top, those two bars at the top, those are the two principal scoring metrics that the courts use to evaluate whether or not someone should remain in custody. Mr. Espinosa has no violence in his past, but he is clearly a drug addict. And so he has come in and out of the system again and again and again, and has a lot of failure to appears, or FTAs. And what that results in is a recommendation down here in the corner, if I can zoom in. This is literally what the view that the court gets. It says here in the corner, that bottom right-hand corner, where it says to detain. So there is a recommendation by the court to the court from this tool that Mr. Espinosa should be detained. Now pause for a minute. Remember in the beginning when I showed you the constitutional question? What was the constitutional question? It was about whether or not we should be detaining low-risk, nonviolent offenders. So Mr. Espinosa does not fit into that category, and yet he has a recommendation of detention. That's troubling, but not nearly as troubling as what you see next. This is Anthony Gallegos. On the same day, comes into the court and is, evaluated like every defendant who comes into the court system. Look at what Mr. Gallegos is charged with. Aggravated battery of a household member, aggravated assault with a deadly weapon. He punched his girlfriend more than 100 times. He slammed her head into a concrete floor. He strangled her and threatened her with a weapon. The same tool that just told the court to detain Mr. Espinosa is recommending that Mr. Gallegos be returned to the streets of the community. This, in a nutshell, is the source of the problem. It doesn't have anything to do with the intention. It doesn't have anything to do with what people voted for and what they believed they were getting. It has everything to do with implementation. And this is a critical lesson for you as leaders in the business community when you think about what is being presented in the form of a constitutional amendment. Whether or not the language and the implementation are actually going to match the intention that was put before the voting public. So what does it look like in terms of the composition of the individuals that we move to detain? Not surprisingly, given the constitutional directives and the framework that was presented and passed by the voters, In the last 4+ years, 4.5 years, my office has moved to detain a little over 5,000 people. Of those 5,000 individuals, 70% are there for a crime of violence. 70%. It's worth bearing in mind because when I show you the recommendations of detention from the court and the court metrics, you'll see that things are wildly misaligned in terms of what the court is seeing as a recommendation. But before we get to that, I want to show you why it's so important to think about moving to detain people who commit crimes of violence. And it's also worth noting that violent crime as compared to the total composition is relatively small. Okay? This is a small population, but a prolific population. And it's a manifestation of the things I've told you many times before. It's the old 80-20 rule. We've got 20% of the population driving about 80% of our violent crime problem. And so the solution needs to be concentrated there. If you look at new criminal activity, this is the activity of individuals who come back into the system after their first charge. Not surprisingly, if you come in on a drug case, on the initial case, the next case usually come back for drugs. Same thing with property, same thing with public health and disorder. Look at violent crime. Violent offenders, if you come in on a violent crime, you're much more likely to commit a new crime that is categorized as a crime against a person, a violent crime. So they overall make up a small segment of the population, but their new criminal activity is 3 times more likely to be violent as compared to everyone else in the population. So what does that mean? What you see here on the right, this is the recommendation of detention that's coming out of the courts. And look at the disparity between when we move to detain somebody and when the Arnold tool is recommending detention. My office overwhelmingly moves to detain violent offenders because that's what the community voted for. That's what you expect us to do. The tool the judges rely on overwhelmingly recommends a much broader composition that includes property offenses and drug offenses. And this has dramatic consequences for the system. This is a comparison of the failure to appear rates. And when you're wondering where does this data come from, this is court data. This is data that was presented by the court. And what we're looking at is a comparison of this jurisdiction as compared to other jurisdictions across the country. The top red bar is Bernalillo County. That's the failure to appear rate as compared to Kentucky, Cook County, Illinois, New Jersey, and other jurisdictions that have implemented bail reform. This is the safety rate. This is the rate at which individuals can be maintained and supervised in the community without picking up a new charge. Once again, we are well below the performance of other jurisdictions, in part because of this misalignment. Right now, our detention outcome has hovered around 50%, and historically, it has remained at around 50%. Here's one of the more astonishing facts, and something that, frankly, I can't explain under any framework, under any rubric. I have no explanation for it. I actually lose more detention cases when there's a firearm involved than when a firearm is not involved. And it's one of the more bizarre aspects of the system that we have created. And we've done some analysis here. We actually separated out violent crimes generally and violent crimes that include firearms, property crimes with and without firearms, drug crimes with and without firearms. In every instance, the presence of a firearm actually has the demonstrated effect of lessening the chances that someone is going to be detained. Now, take a step back. You live in a community that is being rocked by gun violence. You live in a community that is being rocked by gun homicides. You don't need a rubric. You don't need a framework. You don't need a data-validated instrument to tell you that something is very, very wrong in this system. How do I know? Well, one way I know, and something that I've been proud to have established and continue to pursue, is a partnership with the United States Attorney's Office, which enables me to take certain felony firearm cases and refer them to the United States Attorney's Office precisely because there's a vast disparity in rates of detention. The only thing that's different between these 202 cases that have been referred is that one hearing occurs on the north side of Lomas in federal U.S. District Court, and one occurs on the south side of Lomas in state court. They are the same defendants. They are the same charges. They have the same criminal history, and yet look at the differences in detention. The detention rate in federal court is 91%. The detention rate in state court is 62%. This is an apples-to-apples comparison of what a jurisdiction looks like when they have a framework that works as opposed to a framework that doesn't. This is actually outdated data, and my team is working on updating all of this because it's only current through February of 2020. I don't know if you realize this, but something happened last March that kind of screwed up our ability to do some advanced analytics. But we're trying to update this data. But through February of last year, the 10-year criminal history of the then 1,500, but now closer to 2,500 defendants that we have moved to detain. Look at this, 6,900 criminal cases between them, 2,400 violent felonies, 532 aggravated assaults, 135 armed robberies, 101 rapes, and 49 murders of the individuals who were released back into this community. Now you will hear, and it has been argued, that this system is working in part because the individuals that we have moved to detain have not committed new crimes while under supervision. It's a little bit of a logical fallacy included in that, and you'll forgive me as somebody who went to law school and studied a bit of philosophy in undergraduate. There's a little bit of a substitution in that analysis, because what we are saying is a certain percentage of these individuals have been arrested. That is not the same thing as saying that a certain percentage of these individuals have not committed new crimes. What do you think the clearance rate for gun crimes is in Albuquerque? I can tell you right now that the clearance rate for homicides is under 50%, and the clearance rate for gun crimes is much less than that. Now, I don't make the assertion that I know definitively that these individuals are responsible for committing all of those unsolved gun crimes. But I have a hunch, and I think you do too, that if somebody has a long history of committing crimes of violence, and they have recently committed a crime with a gun, that if you're going to start looking somewhere to get a handle on your gun and violent crime problem in a community, you probably should start there. This also, though, has real world and real life implications. This isn't just about statistics. This isn't just about numbers and an ongoing debate about statistical models. This is about real life. And in real life, Devin Mumford picked up a charge in December of 2020 where he was shooting a loaded .45 out of his car and was carrying around fentanyl in this community. My office moved to detain. And the reason we moved to detain is the obvious overlap between drug trafficking and gun violence. There is a split second where a drug transaction between two 19 or 20-year-old, usually young men in a parking lot, can go from a completed drug transaction to a homicide. I cannot tell you how many times we have seen an escalation of these very basic drug transactions into violence, into homicide. We had a case in my office that we solved that was unsolved by the police department where a young man was murdered over an ounce of marijuana. And the people that murdered him indicated that they wanted to buy it for somebody's Valentine's present, for Valentine's Day. And instead of paying him the couple $100s that they would expect for that marijuana, they just murdered him. So make no mistake, there is a clear connection between drug trafficking, guns, and unsolved murders and homicides. This is who we lost. This is Devin Hayborn. His mother recently wrote an op-ed in the Albuquerque Journal trying to illustrate the impact that this has. But he's not the only one. There have been 6 murders committed in this county alone that I know of that have been committed by individuals who we moved to detain who have been released out into the community. And the fundamental question that I put before you is how many is too many? How much before we decide to take action? Is 10? Is it 12? Is it 15? Because I can guarantee you, if we don't do something, he will not be the last person who loses his life. And by the way, back to the Arnold tool, this is the Arnold recommendation. This is the data-validated instrument that you hear so much about. For Mr. Mumford after he committed the murder, it recommends that he be returned once again to the streets of our community. This is not working. And anyone telling you that it is working is not telling you the truth. We have to have the courage to take it head on and fix this problem. Fortunately, in this case, after the murder was committed, and by the way, he didn't just stop at murder, he was wearing a GPS monitor when the murder was committed, which is part of the reason we were able to solve the case. He also went on to commit an armed robbery and brandish a shotgun at a woman in the community, all in one weekend. Mr. Mumford had a very busy weekend. He's not the only one. This is Paul Apodaca. Paul Apodaca recently confessed to multiple murders committed in the 1980s. High-profile, unsolved murders in this community. First-degree murder. He has a criminal history that I don't have time to go through. It includes sexual assault, violent crime. This tool recommended that Mr. Apodaca be returned to the community. A confessed multiple murderer with a lengthy 30-year history of violent crime. We have the ability to change this system, but we have to have the strength and courage to do it. Fortunately, we have a solution. And the solution, not surprisingly, comes from those jurisdictions that have been doing this effectively for the last 40 years. It comes, frankly, from the federal system, where I spent a good deal of my life, both as a prosecutor in this office, the U.S. Attorney's Office, and in D.C. It involves what are known as rebuttable presumptions of detention. And I will walk through what rebuttable presumptions of detention really means, because there's been a fair amount of misunderstanding about it. But what it means, in essence, is this. If we can establish probable cause that the charged individual has committed one of these enumerated crimes, then the presumption should be that that individual should remain in custody. People like Paul Apodaca, people like Devin Mumford. Now, it does not mean, and it has been reported, that it is the responsibility of the criminal defendant to prove that they should be out. That's not how it works, and I'll walk you through the framework here in a second. But if you're accused of murder, manslaughter, aggravated battery, sexual exploitation of children, aggravated criminal sexual penetration, robbery in the first or second degree, human trafficking, if you brandished a weapon or discharged a weapon, if you inflicted great bodily harm or caused the death of another person, these are things that would lead to a higher rate of detention. Now, I put the question to you. Is that more in line with what you thought you were voting for when you voted for the constitutional amendment? And I think the answer is yes. This is the framework, and it's important to clarify this. Upon a finding of probable cause that the defendant has committed the offense, the presumption arises, and once the presumption is invoked, the burden of production shifts to the defendant. However, the burden of persuasion regarding flight risk and danger to the community always remains with the government. And even if the defendant's burden of production is met, the presumption remains a factor for consideration by the district court in determining whether to release or detain. In other words, as has been misreported many times, it is the responsibility still and always, as it should be, the government's burden to demonstrate that this person should be detained. That burden then shifts to the defendant to produce something, right? I'm accused of first-degree murder, but I live with my mom and she keeps an eye on me and I volunteer at the church group, so I'm totally fine being in the community. You can make that argument. Those types of arguments get made in U.S. District Court every single day. They don't tend to win the day, but that's an example of the type of burden of production that a defendant can advance in order to justify their release. It's a critical step in the right direction. But again, it is not an attempt to throw out the entire system. It's an attempt by statute to fix it. This is something that I have advocated for, oftentimes, frankly, by myself, for the last 3 years. But fortunately, the governor has recognized the need for change, and I am extraordinarily glad and grateful for her support, because without her support, we won't be able to implement the change that we need to protect this community. There are a number of other proposed pieces of legislation: fixing the statute of limitations for second-degree murder, making the penalty associated with second-degree murder a penalty that cannot be suspended or deferred. We also propose an increase in penalties for aggravated fleeing, because we recently convicted a young woman of going through an intersection, fleeing from law enforcement, and the claim was that it was a terrible accident. She killed a mother, she killed a young girl in Sandia High School, and under the current framework, she was not able to be sanctioned under the murder statutes or the homicide statutes. So we proposed an increase in the penalties there. Gun safety. This is something that I have talked about routinely. The need for stiffer and stronger gun penalties that mirror the federal system and really ratchet up the penalties whenever someone brandishes a weapon or discharges a weapon in the community. Protecting victims. Representative Dixon is advancing a bill that I think is extraordinarily important, because we have child sex and abuse victims who are subjected to pretrial witness interviews and face repeated trauma at the hands of criminal defense attorneys who will ask questions like, what were you wearing when you went to bed? What was it like to have intercourse with that adult? And this is pretrial. In the federal system, that's not permitted. Why? Because it harms children. And it's a basic form of protection that I think we need. And last but not least, and this is something that I always strive to do, especially in this room, we can't just look at increased penalties. We can't just look at greater detention. We also have to think about the upstream investments that we can make to prevent violent crime in the first instance. We need a lot more in mental health. We need a lot more in drug treatment. We need a lot more to prevent the kind of instability in families that ultimately leads to violence on the streets if they remain unchecked. So I encourage you to think about these proposals, really talk to your friends, talk to your family, and more than anything else, as I always tell Bob, when you go to Santa Fe and you advocate for change on tax policy or regulatory policy or any of those other things, remember, if you don't solve the crime problem in this community, nothing else matters. You will not build the kind of prosperous, dynamic community that we all deserve. You're not going to attract investment. You're not going to attract highly skilled talent from all over the country. This has to be a safe community, but we can fix it if we do it together. Thank you. I agree with you that the mental health component, the substance abuse components are having an extraordinary impact. And I would imagine that criminologists looking at the last 2 years are going to do some incredible work to verify what I see as the most basic and obvious connection, and that has to do with adverse childhood experiences. Adverse childhood experiences, early childhood trauma, sexual assault, being raised by an addicted parent, having a parent incarcerated at an early age. These are the numbers that came out of a study of the juvenile population in Bernalillo County. 75% of the boys and 87% of the girls in detention reported exposure to 5 or more adverse childhood experiences. That's trauma. That's early childhood trauma. What we are living through now, what we are seeing on the streets in the form of Devin Mumford and defendants like them, is the ultimate manifestation of policy failure and the failure to invest in at-risk children 20 years ago. That's the core of the problem, because it, to your point, fundamentally alters the neurological pathways. It changes how they react to stress. It changes how they react to perceived threats of violence. If we don't get a handle on that, the short-term solutions that we're talking about in the criminal justice side will not win the day. Ultimately, it's easier to build strong children than repair broken men. That's what this is about. That has never been more true than it is in our community. So how do we fix it? Well, look at this. This is the United States. These are prevention service rates in the United States. This is investment dollars. Look at the right-hand graph. 25.1 per 100,000. Look at New Mexico, 1.7. We are failing to help at-risk children. On average, there is nearly 10 CYFD call-outs for those incarcerated juveniles before they're incarcerated. So the police officers, when they go to a call-out for a domestic violence situation or an addicted parent or a down and out, and there's a child there, if you don't do something for that child, if you don't bring a parent or a person or an adult who cares about them into their lives, what are they going to do? They're going to go out into the street. They're going to try and build a family that they cannot have at home on the street with a gang. And that family needs you to earn your keep. That means sell drugs. And the first time you get ripped off on the street, you know who you can't call? The cops. So you know what you do? You get a gun. So now, I'm a kid that has 4 or 5 or 6 adverse childhood experiences. I can't go home. I'm selling on the streets. No one cares if I come home at all, and I've got a gun. And I meet my counterpart in a parking lot in your city at 2 o'clock in the morning. That's the problem. You ultimately need to build a situation and a system where you no longer look to me or the police to have a safe community. You need to live in a community where this happens less. And in order to do that, you have to fix the underlying support systems for these kids. Look at these figures. 99.5% of the kids in juvenile detention have a major psychiatric diagnosis. Struggled with depression, PTSD, substance abuse. Look at the substance abuse disorders. Do you know how hard it is to get somebody who is addicted to methamphetamine, even at the age of 17 and 18, to get off of meth and get into a life that's productive and healthy? It's almost impossible. Here's part of the issue. We spend a whole lot of time talking about diversion and treatment at the back end of the criminal justice system, and I, of course, support every bit of that. We need to find these kids when they're 4 and 5 and 6 and 7 and make sure they never go down this road. And a lot of times we have a conversation about money. We have a conversation about how we can afford it. And one of the things that we see is that the investment dollars are, you will yield so much return on this investment. It costs you, as a community, $45,000 a year per year just to put someone in a box at DOC. That doesn't count the costs of the police, the judges, the defense attorneys, the social harm, the economic harm to victims. $45,000 a year. Every year I keep that person at DOC. What if I spent $4,500 a year for 5 years, 15 years before they ended up in prison? You can save lives and you can save money. You have to start thinking about child welfare and neglect as a public safety investment, as an economic investment in the community. If you do that, you can change the trajectory of this community, but you have to have the foresight to make big investments. And a lot of times, guess what? As elected officials, as people who run for office, you know what the hardest thing for us to do, for any of us to do, is to come before you and say, make this big investment now, and it'll pay off 15 or 20 years down the line. When you're running for office, a lot of times there's a natural pressure to do something now, to give you something in 6 months that I can tell you is going to fix the problem. You have to do both. You have to take the long-range view. If you make that investment, I guarantee you it'll pay off.